There are tons of business podcasts to choose from, but only one has the stamp of approval. Kristin Stampini is South Florida's leading real estate entrepreneur and your trusted source for everything real estate.
I would like to welcome our listeners and thank you for joining us today for another episode of our podcast, The Stamp of Approval. I'm Kristin Stampini, co-founder of the Stampini team with RE/MAX Services located in Florida. I'm also a certified real estate coach with Craig Proctor Systems and the owner of Global Virtual Assistants, where we help small business owners hire, train, and staff very affordable administrative assistance virtually. So the Stamp of Approval podcast was launched to share and educate other realtors, consumers, and other business owners across North America by sharing value and content to our listeners in each and every episode. I share my experiences, triumphs, failures, and strength throughout my entire life with the hope of my audience being able to expand their knowledge on everything real estate, business, sales, and mindset oriented. We recently launched a YouTube channel called Stamp TV Kristin Stampini. I actually share weekly real estate tips focused for buyers and sellers, and also laser focused on move-up sellers. So today I have my friend and attorney, and who I've used in different situations, Alan Rains. Alan is an attorney and one of the founders and partners of Wash Rains. He has 18 years of litigation experience and practices commercial litigation, including business torts, contract, and corporate litigation, real estate related litigation, including construction, condominiums, homeowners associations, and cooperatives, and probate and trust litigation. Alan has so many accomplishments. Just mentioning one was Florida Rising Stars from 2012 until 2016. So welcome, Alan. Thanks for coming back.
Thank you for having me, Kristin.
Absolutely. So today we're going to talk about financing contingencies and escrow disputes. You know, it's a big issue that all of you listening should know as a real estate agent and also a consumer. So let's jump right in. Tell us about what you're seeing.
So the big issue in financing contingencies under the revised FAR/BAR contract from 2017 is what's now deemed to be the loan approval. It used to be called the loan commitment. A lot of realtors still aren't changing their forms addendums to change it from loan commitment to loan approval to be consistent with the FAR/BAR as-is contract from 2017. And why is this important? It's important because the financing contingency, if the buyer's not going to pay cash, that's Section 8A of the FAR/BAR as-is, you're going to check box 8B. And the financing contingency is going to require certain things, certain rates, certain deposits. So let's say, for example, it's a $1 million house. And generally the first escrow deposit is going to be 10%. I'd like 20% if it's going to be a 20% down deal. Buyer's going to put down 10% in escrow. Once the inspection period's over, they're going to put down an additional 10% to bring it to 20%. It's still subject to the financing contingency for the other 80%, closing costs and whatnot, but they're going to potentially have $200,000 in escrow dependent on the financing contingency. And why is this important? Well, Section 8B requires certain things to be done within a certain time. Specifically, you can check whether it's going to be a conventional FHA or VA or other loan. And you need to get loan approval. And if you leave the space blank, it's going to be 30 days after the effective date. What's the effective date? The effective date is not the date that the contract is signed. The effective date is the date it's last signed by the later of the two parties. Let's say the contract was executed on August 18th by the buyer and August 19th by the seller. The effective date isn't the 19th if the seller's agent does not deliver the contract to the buyer's agent until the 20th. The date of delivery is going to trigger the effective date. So everything gets clocked off the effective date, which is going to be the date of delivery of a fully executed contract.
Let me ask you a question. Okay, because all this stuff that you just said, just opened up a lot, especially to the consumers and to the realtors. So number one is when you have an effective date, shouldn't everybody be signing that? So if it's a going back and forth, and now the buyer's agent or the buyer signs on the 18th, then the seller signs on the 19th, but doesn't deliver it until the 20th. Doesn't everybody have to have the date on the final day? So if it's the 20th, I mean, first of all, it should be delivered by the agent before the end of that day. Okay. And everybody should have the same date on the contract, because you can go back and open it up if it's ever in litigation, correct?
So the contract, although it's signed on the date of execution, the 19th and 20th respectively, it does not need to be re-executed if it's delivered subsequent. But as a matter of practice, the agent that's sending the fully executed copy back to the other side that didn't have the fully executed copy, they should say, enclosed, please find the contract dated the date of the last party signing, which has an effective date of today, the date of delivery. Please clock all the deadlines off today. And then everyone's on the same page. So if there's ever a dispute as to the date of delivery or the effective date, there is an email record that says, okay, it was signed on the 19th, 20th, delivered on the 21st. Everybody's on notice. If there's a dispute as to what the effective date is, you can't just sit back and say, gotcha, it was really the 20th, not the 21st. Just say, no. I sent you an email. It was the 21st. You didn't object. We said all the dates were going to clock off that. A court's not going to penalize the other party for, relying on that delivery.
No, and that's a very good point, because it happens all the time, especially in inspection period. So if it says on the contract up front that it must be signed by 5 p.m. on the 19th, and the seller doesn't come back until the 20th, what about that?
You generally want to change that. It happens more often than not with all the contracts that do make it across my desk. You want to change the date to accept it, to initial it, change it with regard to the final version to go back and forth. It's really it's a non-issue, but it just creates an inconsistency for an argument. You want to eliminate the gray areas with regard to litigation if you have the contract. If it says it must be accepted on the 16th and it doesn't get done to the 19th, cross it out, make it the 19th, have the buyer and seller both initial it on the final version so that if there's ever an issue, everybody's on the same page with regard to the date of delivery of the fully executed copy with the time for acceptance.
And the big thing is remember, it's by the delivery. So deliver it the same day it was signed as well. And the reason why I'm really talking about this, because what I see when there's an issue is in inspection periods, and when you have to deliver if you want anything done from the inspection, that's where I see these dates are so important. So, and remember, the FAR bar contract here in Florida is completely different than the FAR contract in the dates and everything else. So you've got to know the different so really working, first of all, with an agent that has high level of experience and expertise, and also working with an attorney is highly recommended. And because there are a lot of things that you got to make sure that are done for you to protect you. And a realtor that is an expert in the field and does a lot of transactions every single year, as well as working with an attorney, can make sure that that any buyer or seller is represented well. So talk about, because there's so many. Now when you have the effective date, let's say it's the 20th of the month, so then they have the inspection period, right? And during that inspection period, because this is a big one, you have to have had the inspection done and delivered anything that you wanted, any type of negotiations during that inspection period, correct?
So the key with the inspection period is you can deliver it to the seller, you can demand whatever you want, but you must, if you're the buyer, if you want to cancel for any reason whatsoever, you don't like the way it looks, your wife or husband doesn't like the house, you don't like the way it smells, whatever reason you want, must be communicated in writing to the seller that you are exercising your right to terminate the contract under the right of inspection period. Now, why is this important? Because if you look at, and there's a lot of confusion on this with regard to section 18F, if your right of inspection is 10 calendar days for the date of delivery. If it lands on a weekday, Monday through Friday, you have until 11:59 p.m. to deliver written notice that you're exercising your right to terminate under the inspection period.
For the FAR bar
For
contract.
the FAR bar as is contract. Now, what's interesting is Section 18F deals with what happens if the 10th day from the effective date lands on a Saturday or Sunday or a legal holiday. Well, Section F says instead of 11:59 on the weekday, if it lands, let's say on Sunday, let's say it was Sunday the 18th was the 10th day. That's going to carry over to Monday the 19th. But the language in Section 18F says it's only to 5 o'clock p.m. on the following business day. So you're dealing with 7 hours less time. And if you're not cognizant of that and you send the termination letter at 11:59 p.m. on Monday, you've now blown your deadline by 6 hours and 59 minutes, and you no longer have the right to cancel for any reason you want. Now you're potentially trying to engineer a financing contingency denial in order to get out of this. And guess what? You've now subjected your initial deposit, potentially your second deposit if you make it, to forfeiture if you don't close.
Yeah, and wow, that was full of such good information. But the inspection period, so you guys know, and so really the sellers do know as well, they can back out during the inspection period for anything they want. They do not have to have an inspector during that time. So just realize they get their deposit back as long as they do it during that inspection period. They get their deposit back for any reason, any inspection, that it can be canceled for anything. If they do not like that there is a piece of dirt on your floor, that it does not matter. Pretty much they can get out for anything. So just know that. Secondly, if you are negotiating because you had the inspection, let's say it's 10 days, on the 9th day, I send over that these are the things that the buyer want, and I never hear back from the agent, that I'm still okay, right? Because I gave it in the 9th out of the 10th day. I'm still fine in the negotiation, even though I haven't heard back from the agent.
In an abundance of caution, always terminate within the inspection period. The worst case scenario is you extend the inspection period later if you don't hear back, or you just enter into an addendum extending the time period. But the one thing you can never get back is the right to terminate during the inspection period. When in doubt, terminate it. You can always fix it later. But what you can't do is not terminate it, go past the inspection period. You've now subjected generally your initial deposit to forfeiture if you don't close for cash.
Yep, that's good. And a lot of times what we do is we'll do that, or we'll make sure that we extend the inspection period immediately. So we'll send in what we want on the buyer side, and then we'll say we need a 4-day extension to the inspection period. So and they do that, okay? And we make sure that we have receipt of sending it. Okay, so let's talk about, because this is crazy how people, now you're talking about what the contract says as far as the lender, right?
So let's talk about the financing contingency in Section 8B. So this is the other basis that you can use to cancel the contract, notwithstanding the inspection period having expired. And a lot of people will attempt to cancel the contract even though they don't have the right under the inspection period now under the financing contingency if they get creative. And
you know what? When a lot of people tell the lender, hey, just say that I'm not, just so you know, by law, the lender's not allowed to say that you're not, that just because you want out of that contract, the lender is not allowed to just go and say, oh, they no longer qualify. So putting the lender in that situation, they're not supposed to do that.
There's a number of issues to be litigated if it does get there. And let me discuss about certain things and talk about a due diligent, good faith effort to secure financing. So Section 8B provides that the buyer, if they elect to do financing, they're going to pick, let's say, for example, it's a conventional mortgage. They don't fill in the blank, 30 days after the effective date, and that's going to be the loan approval period. And then they have to check one, is it going to be fixed, adjustable, fixed rate, or adjustable loan amount? And then this is the biggest issue is at an initial interest rate not to exceed, if blank, this is the key issue right here, then prevailing rate based upon buyer's credit worthiness. What is buyer's credit worthiness? If you have a 650 credit score, you are generally going to pay more of an interest rate than somebody with a 750 credit score. You don't get to arbitrarily tell the lender, like the case that I have that I'm dealing with on a $2.1 million house in Lighthouse Point, I want a jumbo loan at 3.99%. And if you deny me based on that, it's not, I get to walk away. So the contract provided, the one I'm dealing with, or prevailing party interest rate, is at 3.99%. I have no idea. I don't know what the guy's credit worthiness. I don't know what his credit score is. I don't know what his debt to income ratio is. It's a jumbo loan. It all depends on how much he's putting down. There's a number of factors. So then the other issue is in section 8B, Roman numeral 1, buyers shall make a mortgage loan application for financing within blank, if less blank, 5 days after effective date, and use a good faith and diligent effort to obtain approval of a loan meeting the financial terms of loan approval and thereafter closing the contract. So this is a big issue. 5 days from the effective date, I have to complete a loan application. So if I fill out a loan application and write my name on it and give it to the mortgage broker that's handling my deal, is that a completed application? It seems like I'm missing a bunch of stuff. If I give them everything they want and then they ask for additional information, is that a completed loan application? It's going to be a gray area as to when the loan application was made, but if you don't submit at least the information requested on the loan application, have your tax returns ready, those types of issues, it's not going to be deemed to be a loan application submitted within 5 days. If the lender's underwriting department says, look, you own your own business, we have questions about certain deposits, we have questions about your disbursements, your K-1s, your salary, we need additional information, that's additional underwriting. That's not going to be deemed to be the initial round of loan approval. And this is key because a lot of times a buyer will wait until, the 24th day when they have 30 days to get loan approval, actually submit a completed loan application and then say, I didn't get loan approval within 30 days. I'm backing out of the contract.
So let me talk about this real quick. Okay. From a realtor side. So a lot of people and a lot of realtors don't realize it. And even sellers or buyers or whatever is you are sitting there and you are saying that you can have a loan approval within 30 days. And now your contract is closing in 30 days. Okay. The seller has already moved out. And now on the 30th day, you have got the buyer who has been denied. You have to be so careful. And again, why you have to work with experts in the field to know all of this, because it happens so often. And I see it come to us all the time on our listings where the agent will say, okay, they need the loan or they're submitting the loan approval and it's 25 days and we're closing in 30. Well, heck no, I'm never going to put my seller into that situation that they're going to be moved out, maybe already closing on another property or going into a rental or whatever. And then day 25. So my point is either extend the closing when you put it in, like 45 days instead of 30, or make sure that the loan commitment is much sooner. Now, is that always going to be the case that you can get that from the lender? And the answer is no. So you, as the agent, needs to talk to the lender to really see when you can get a loan commitment. Sometimes they can do it in a week, sometimes 15 days. Depends really on what the buyer's already turned in. But just know you're putting it at risk more for the seller also to have to move out of the home. So, there's so many different things here.
So if you're the seller, although I sound a little skeptical, the deal is never closed until it's closed.
That's right.
If you move out and you go rent an apartment, I'm dealing with this on a transaction right now in Parkland where it was a cash deal. The buyer was supposed to put 20% down. Same realtor was representing both sides of the transaction. The closing date comes and goes, and the seller says, okay, great, I'm going after the deposit. You failed to close. Lo and behold, the agent handling both sides of the deal never collected the $200,000 deposit. And they already rented a house in another area, moved out, and basically learned that this deal wasn't going to close on the date of closing. So generally a good idea. You want to be involved, and there's language in an addendum you can add that the seller and the seller's agent is allowed to communicate with buyer's mortgage broker to be kept apprised of the process, know what's going on, and you generally do not want to have the loan approval period expire on the closing date. If you make the closing date 45 days and the loan approval period 30, and you get loan approval in 15, you can always move up the closing date. You need to get consent from the parties to move it back, unless there's a title issue, which would trigger another provision on the contract. But you generally don't want to have the closing date mirror the loan approval.
And it happens all the time, because you can also do on or before. But the other thing is here that Alan was talking about with the loan approval, and it's in delivering the commitment. Usually on that commitment, there are terms that are also, let's say there are 5 things. Okay, so here's your commitment at 25 or whatever days, 20 days or 30 days or whatever the days amount is. But I still need to see A, B, C, and D. Okay, so it's basically saying, yep, here's the commitment delivered back to you. However, it's still telling you, nope, it's not 100% commitment because we still need these things. Okay, just so you know, they still have, because they delivered it to you, the buyer's still safe and they actually can still get out of it if these 4 things or whatever's in the commitment letter don't go through.
And kind of an extreme example of that is, let's say you get your loan approval, everything's set to close, and part of that loan approval is that you're not going to undertake any new financial obligations that would materially change your debt to income ratio. Well, what happens if the buyer goes out and leases a Ferrari for $3,000 a month, and now they're not eligible to make for the type of loan they want? That's going to be an issue, and generally the lender's not going to loan on that loan, and they're going to hold back the money, and the deal's not going to close. Is that a due diligent effort? So, then the next issue is, let's say you have an escrow dispute. The case law that's been around for many years, and as recent as 2011, the BLT Now LLC versus Coldwell Banker real estate case out of the 3rd District Court of Appeal from 2011, provides the issue of whether a purchaser exercises due diligence and makes a good faith effort to secure the requisite financing is ordinarily a question of fact for the trier of fact. What does that mean? That means, once we talk about the conditions preceding to filing a lawsuit for the escrow, dealing with the exercise of due diligence and good faith effort to secure financing, you have to go to trial to have that issue determined. That could take a year, year and a half, 2 years. And if you're dealing with a situation, let's say it's a $200,000 deposit, your money that you paid for this house in escrow is now frozen and no one can touch it until this issue is adjudicated at trial. It may not be an issue for some buyers, but for other buyers that are counting on that 20% down or even 10% down, it's a huge issue, and it's going to prevent them from buying another house.
Let me ask you one question. So if you are basically, if it says that you have the loan commitment within 25 days, but I have 4 things on here that still I have to make sure that I doubled, and it's stuff that should have already happened during the loan commitment, but they're covered because it's in the email or whatever, where it says that they still have to double check their job, okay, or whatever, whatever it is. Let's say at 30 days, oh, nope, they found out that their job was not whatever it was. Are they still able to get that escrow back?
If you're terminated from your job on the 29th day, that's going to be an objective requirement. They're going to say, look, we can't loan the money. That's going to trigger the financing contingency out. You're going to get your escrow back.
Yeah. So sellers, don't think, just like what Alan said, until it closes, the buyer can get their escrow deposit back so many different ways. Okay. So don't think it's closing until the day of closing. Really don't. Right.
And it's a big issue if you're doing simultaneous closings. To sell one, buy one, you generally want to hedge. I mean, not that there's going to be an issue, but if there is an issue, it's a major issue. You're generally dealing with large sums of money, potentially the largest transaction that buyer and seller have been involved in. You really need to be careful about making plans and commitments until the deal is closed.
Yep. So give a couple of closing tips of what you really think that should happen during this process, and also give your contact information so people can reach out to you if they want to hire you for one of their transactions.
Sure. With regard to the financing, the loan approval, if you are the seller, you want to be in regular communication with the buyer's loan officer, lender, to get updates on their approval. If you think there's going to be an issue, you may want to have a discussion with them and say, look, this isn't working out. We're going to start taking backup offers, which you're allowed to do, or you can potentially just agree to terminate the deal, give them their escrow agreement back. If you think they're making a good faith due diligent effort and they're just not going to make the time frame in order to close a deal. Because at the end of the day, the seller wants to sell or the buyer wants to buy. But if there's going to be issues, you're better off terminating the deal before there's an issue. In order to avoid an issue under the FAR bar as is, if there is an escrow dispute, you need to be aware that Section 16 deals with dispute resolution. And if the buyer and seller both make conflicting demands to the escrow agent, the parties then need to go to mediation. And the big thing with mediation under Section 16B is mediation. Let's say we have a dispute this week. It may take 30 to 45 days to select a mediator, actually find the mediator's schedule is coordinated with both attorneys, because we all work on different stuff. So let's say you get the mediation scheduled 45 days out. Then you go mediate, and one of the attorneys is saying, well, I want, not only do I want 100% of my escrow, I want all my fees and costs incurred with attending the mediation. Not so fast. The FAR bar as is says each party is going to bear their own fees and costs in conducting the mediation. And then after the mediation, if a lawsuit is filed, then the parties are on the clock for prevailing party fee claims for the other side. So buyers and seller need to realize you're paying your own attorney's fees through mediation. It's generally going to take at least, more than likely about 2 months after you get the conflicting demands, because you got to wait a 10-day period. Then you got to schedule mediation, and then you got to go file a lawsuit to go deal with this issue. And even if you fast track the lawsuit and get everything done as soon as possible, you're still looking at approximately 6 months from the filing in order to get a trial date and go try these issues. Your money's going to be tied up and you're not going to be buying another piece of property. So if anyone's having an issue with regard to an escrow dispute, even if it's past the date of closing, you've got conflicting demands, my firm and I can help assist in potentially resolving those issues. My contact information is, the firm name is Wash Rains, W-A, S as in Sam, C as in Charlie, H as in Henry, Rains, R-A-I, N as in Nancy, E-S. We're located in Boca Raton at Military and Butts at the Crystal Corporate Center. My firm's phone number is 561-693-3221, and my email address is arains@washrains.com. If you want to email me or call my office, we're more than happy to help you out if you may have any questions regarding escrow disputes or any issues in connection with a failed closing involving a real estate contract in Florida.
Wow. Such awesome information. Thank you so much to the listeners, and thank you, Alan, for joining us on this episode. Bye, everybody.
Thank you.